Good morning. As you're logging in, you're very, very welcome. We have a lot of interest in this webinar this morning, a lot of people logging in, so we're just going to allow another moment or two to make sure everybody gets logged in successfully. Good morning. If you've logged in, we are just going to allow another minute just to enable everybody to get logged in. We have a lot of interest in the webinar this morning, as you'd expect. Okay, good morning. And you're very, very welcome to this latest in a series of webinars provided for us at CEF by our very, very friendly and helpful legal patrons, Mills Selig, who've done a fantastic series of webinars for us. And actually, there are more to come, so I'd advise you to refer to our website and get yourself registered. We have webinars coming up on the use of drones, which is huge in the industry, and the issues you may have around drones, succession planning, useful tips for terminations, and intellectual property rights. So we have a lot more to come in the series, but we're very grateful to Mills Selig as ever for their support in all these matters. And to remind you that as members of CEF, you can avail of support from Mills Selig as well on particular issues. So again, all information on our website. This morning, the topic is renewable energy projects. So obviously huge interest in that. That's going to be presented by Glenn and by Conor from Mills Selig. I'm going to be handing over to them in a moment. I would just ask you this morning, as you're participating, we would encourage questions. So if you're familiar with Zoom, if you go down to the bottom of your Zoom screen, you will see a Q&A button. That's the place to pop in your questions. And at the end of the presentation, I will pick up those questions and pose those to Glenn and Conor. So do please feel free to ask questions as we go along. With no further ado, Glenn, I will hand over to yourself and Conor, and we look forward to hearing what you have to say, and we'll speak again at the end of the presentation.
Thanks, Mark. Thanks for having us again, and welcome everybody to the latest in the series of webinars from Mills Selig, particularly if it's your first one. For those of you who don't know who we are, Mills Selig is a sort of local and independent law firm where we're experts in corporate and commercial law matters. We pull together a lot of different departments: commercial law, commercial litigation, private client, corporate employment, all those sort of things. And what we do is we have a sort of 360 approach to business law, and making sure that we can tailor our advice to cater the needs of our clients, especially in the commercial sectors. Renewable energy, we've got a short definition of that up on the slide there. Essentially, it'll not be unfamiliar to everybody on the webinar. Renewable energy means energy that is sustainable and something that can't run out or is endless. Particular focus today, it's going to be on projects sort of from inception to completion and beyond. So we'll go right through from somebody wants to set up, for instance, a microgeneration station and carry you through the things you need to be looking for from a legal perspective, your consents, your authorizations, all of your contracts, and right through the stage where perhaps you're refinancing or looking to sell, invest into, or divest out of particular projects. We are going to focus on the main renewable energy projects that we come across in Northern Ireland. And that is wind, which I'm probably going to refer to the most in the webinar, and Conor as well, because it is the biggest area that we see, particularly in this part of the world. Also anaerobic digestion, and finally solar. The concepts and issues that apply to those three types of renewable energy sort of generation stations, they're all pretty much the same. Anaerobic digestion plants, there will be a lot more contracts with, for instance, your feedstocks, your offtakes, and management agreements. The other types of stations and equipment sort of look after themselves a lot easier, whereas the anaerobic digestion station does require contracts between the person who's maybe operating the site or the landlord, if the site's leased. So the areas we're going to cover today is really from the start, what interest you're going to require in the land if you're setting up a microgeneration station project. Requirement to get your planning permission to erect the unit, grid connection, which in nearly all of the stations you're going to require grid connection to export, and usually with wind import power. Your construction contract, if it's a third-party constructor, obviously given this is a webinar for the Construction Employers Federation, a lot of companies may just be constructing their own turbines and other equipment, but if you're setting this up as a sort of promoter who's not in the construction sector, you're going to require the construction contracts, and a lot of those attendants probably will be on the other side of the construction contracts, being the constructor. We're going to look at the corporate structure of projects and ownerships and responsibilities. That's something that's very, very important to keep an eye on from the start of your project, to ensure that you have the things set up right legally. Everybody has the interests that they're going to require in it, and it's not going to cause any headaches from a tax or legal perspective. And then finally, I'll touch briefly on divestment, investment, refinancing projects, and things that happen after commissioning. You're going to hear me refer a lot to ensuring you have your consent, your contracts, your project rights and everything in writing, clearly documented. All the information and details on those contracts and consents is accurate. It reflects the owner of the project, and the reason for that is, I suppose, renewable energy projects in Northern Ireland have been probably we first started seeing things happening on the sort of smaller scale in the microgeneration sort of 2004, 2005. And as with a lot of stuff in Northern Ireland, people kind of just winged it to a certain extent, did the applications themselves, didn't take proper advice, used contracts maybe that they'd found online, didn't have contracts, didn't have agreements, had permissions, had grid connections in wrong names. And what we've seen as London investment firms or energy providers, suppliers across the water, and bigger outfits in Northern Ireland came to invest in, came to finance or acquire projects, that a lot of these projects actually hadn't got the right contracts, and it's caused a lot of headaches for people down the line, and a lot more expense and time to put things right later in the stage. So forgive me for telling you 10 times that you need to make sure that everything is clearly documented and you know, has the right parties and all those sort of things. So firstly, interest in land and project property. There's a bit of a change to the advertised panel. Anna Marie McAlinden, who heads up the energy team with me in Mills Selig, was supposed to join us today, but due to unforeseen circumstances, she's been able to make it today. So I'm going to cover interest in land and things, and if there's any particular queries on that, hopefully be able to deal with that at the end. And otherwise, look, we'll have Anna Marie's contact details, and you can get in touch with her. I suppose the first thing to think about when you're setting up your renewable energy project is, okay, I need to have a site. A lot of the early stage projects were people who had a bit of expertise in wind turbines, in anaerobic digestion, and they were taking leases off usually farmers, given the sort of the nature of where a project had to be, and the ability really only to get plan permission for these things out in green fields. There's more than just making sure you've got a piece of land if you're taking a lease interest, than finding a site, finding a good rent, those sort of things, and finding a landlord that's going to give you access to property. The availability of a suitable grid connection is one thing, so that'll just depend on, you know, where are the most closest NIE substations, what is the grid supply like in certain areas. The grid in Northern Ireland has sort of not the most modern of setups, and really you see the bulk of the energy projects focusing in around the west of the province, the southeast, and sprinkled around County Antrim, but it's really to do with having a suitable grid out to the country fields. Obviously, it'll go without saying, but some people don't think about it, is just making sure that you've done your wind assessments, that the site you're taking has an adequate supply of wind and light for solar. The likelihood of obtaining planning permission, I mean, the things you have to think about with planning applications is, you know, proximity to transport links, close to other people's houses, and where there are particular issues that the local council's planning departments are not going to turn a grant, or other people are going to object to your planning application. Again, likelihood of securing land rights, that's something that you're going to have to get into discussions with certain landlords. You need to consider, pardon me, that you need more than just your lease. You need other rights as well. You need to make sure you've got easements over access routes from main roads, particularly when you go to construct the turbine or the anaerobic digestion plant. You're going to have to make sure you get, you know, your large trucks and your cranes and anything else that you need to set up to the site. Visibility displays, access to the main road, or other issues that you're going to have to consider. So a bit of planning needs to go in at the outset to what a suitable site is. When you come to stage, then when you're ready to enter into your lease with a landlord, way back at the start, what we saw a lot of was options to lease, and options over a agreed form lease that were exercisable unilaterally by the prospective tenant. What we see more now is an agreement for lease, which is essentially an agreement between prospective landlord, prospective tenant, that an agreed form of lease that's negotiated at the stage that agreement is signed is entered into upon certain conditions being met. What you're interested there is to make sure that before you commit any expenditure, time and effort into these projects, to apply for your grid, to do feasibility assessments, technical assessments, all that sort of stuff, that you're not paying rent. You're maybe paying a bit of a premium to have that agreement to lease, but that the lease is sort of set up and ready to go once you receive all the things you know that you need to kickstart the project off. So once, as I said, the conditions in the agreement for lease are met and complied with, a lease will be completed, and the terms of those will include the following. So the term of the lease, so what the duration of that is. We've said there that we often see 20 to 25 years. That's going back to periods when there were the incentives, the NIROCs that were available, because that was sort of the expiry period in those typically. It also had a sort of implications from the lifespan of a wind turbine, of an anaerobic digestion unit, in that people who were setting projects up, promoters, were keen to make sure they just had the lease term for the sort of maximum lifespan of the project. Lease will also need to ensure that it retains ownership of the equipment, any electrical equipment, I suppose civil works that need to be done, and obviously the turbine itself and everything that all the components of that. Particularly at the end of the project, we've seen leases where turbines have been given to landlords at determination of the lease. Rent, obviously, one of the most important things. Initially, when projects first started happening in Northern Ireland, we'd seen a lot more percentages of revenues, percentages of exported power at a fixed price as the rent. It's starting to go back a little bit more towards sort of fixed price rents with annual reviews, uplifts only. The lease is going to need to deal with termination as well. Obviously, as the tenant, you're going to need to make sure that the ability for the landlord to terminate in the event of a material breach of the lease is as limited as possible. As a landlord, you'll want to make sure if the tenant does anything that's troublesome to you, troublesome to the site, is doing anything untoward on the land, that you have ability to stop that and terminate the lease if it isn't rectified. Again, insolvency scenarios are usually in a typical lease included as a termination event. If the project's funded by a bank or other sort of financial institution, typically what you will see is first to have for step-in rights for the funder and a sort of lease direct agreement entered into between landlord, tenant, and the lender, so that obviously the bank or financial institution has a first refusal to step in and take control of the project and look to sell it on as well. So that's sort of one complication with insolvency scenarios. The lease will set out sort of detailed requirements around decommissioning. Often the planning permission will have details of that as well. So it's important to make sure that the lease says, who's responsible for decommissioning, what does the site need to look like at the end of the project, at the end of the lease. Usually there'll be an expectation from the landlord that the site is left in nearly the state that it was found in before any construction happened. There's other rights that are going to be included in the lease as well, just sort of suppose what the landlord can or cannot do near the lease site, and rights for the tenant, maybe to encroach on the lands for certain works, for repairing the turbine, and obviously, as I mentioned before, access and ensuring that trucks, service and maintenance providers can get access to the site to fix it up. There's also some non-contractual requirements for the wind project before commissioning or even construction as well. Electricity generation licenses, they are only relevant for large scale projects with a sort of generation that's not your typical micro generation size. Plan permission and development consent is always going to be required when you're putting turbine up, putting a anaerobic digestion plant on a site beside a farmer's yard or where that may be, and also for solar in fields or on roofs or anywhere like that. We've mentioned there marine licenses. Really, that's just for offshore projects, which we're not going to touch on today. Environmental impact assessments. There are a few sort of requirements, mostly from a planning permission perspective, that you should be aware of when you're looking to set up a site. Depending on where the turbine is, you may require bat studies for if there's bats or colonies of bats in the vicinity. You'll not be allowed to do any construction of turbines during sort of birds nesting season, and things like this are issues you should be aware of before starting, so that you're not delayed and obviously costing yourself unnecessary money. Tied in with the planning permission as well is obviously if you're anywhere near residential houses, the residents or near the turbine would be able to block the planning permission, apply to block, raise objections. If there's going to be a noise issue from the turbine, what we have put in place many times is noise waivers. But again, that is something like an agreement for lease where a premium is going to need to be paid to the local resident, so they waive any right they have to go to the planning authority to say that planning permission shouldn't be granted, or at any stage after the project is commissioned to say that it's making excess noise and seeking to force you to turn the project off, usually in the event of being a wind project. At the end of the life cycle of the wind project, for onshore, which as I've said before is typically 25 years, the project needs to be decommissioned, and I touched on this in the lease. It'll entail the removal of all components of the turbine. So that's something that you need to be aware of just before going in, that, you know, transformers, substation, any other housing that's on the site, civils, foundations, all that sort of stuff needs to be broken down to a depth of around 1 meter, everything removed, and the site sort of left pretty much as it was when you first took ownership of it. That obviously only applies where the site has been leased. If it's own property, then none of those are issues. We've noted there at the very bottom that due to the time frames, lifespan of projects, lifespan of rocks and things, that we're expecting to see a bit of decommissioning happening from around 2030. One thing also to note just on the lease is an ability to repower. In the last 4 to 5 years, we've had a lot of clients seeking to repower their turbines. A lot have been able to do that. A lot have had to pay money to be able to do it due to their leases not giving them that ability. So it's important to make sure that if you have any intention to put up a more powerful turbine, or to change the engine on the anaerobic digestion station, that their lease gives you the right to do that, because if the lease is too specific, you'll not be able to do it without approaching the landlord and negotiating a variation, which no doubt will cost you some money. The next item to be aware of then, which we've mentioned, is your grid connection. This is obviously a little bit more technical. We don't advise per se on actually how you get the grid, but we will do due diligence on projects where we're acting for funders and investors or purchasers of wind turbine sites to make sure it's grid connection, everything is in place. For projects that intend to export electricity, which is going to be the vast majority of projects, you're going to need an export connection. Wind turbines will require import connection as well, because power is required for starting those up at the outset of a day's generation. As I said, it's quite technical in terms of the application process. We've added a link there, which will be available when Mark circulates the slides, of just how you go about with NIE, what is required, what forms need to be filled in with NIE, and sort of time periods and costs of doing that. From a legal perspective on the grid connection, this is one issue that, as I'd mentioned at the start, that we see a lot of inaccuracies in terms of the documentation when you're coming to sell a project, to have investment put into it, to have to refinance your financing. We see a lot of times when people have the wrong name, that the owner of the project may be a limited company. It may be an individual who's built the project, but it's in the name of the farmer whose land it's on, or the landowner, or it's in an individual's name when it should be the company's name. That's not fatal. It can be fixed with a novation agreement, which I'll mention down the bottom of this slide. Property description. Everything needs to be accurate. There'll be lawyers at some stage probably running through these things with a fine-tooth comb, and as much as it may not cost you too much money, it's certainly going to cost you time when you're looking to divest or refinance projects. I would also just advise everybody, if you're constructing a project, solar, anaerobic digestion or wind, retain copies of these documents. Getting them out of NIE again can be pretty difficult and again cost you time. As I've said, that the inaccuracy of the parties on a grid connection, on the 1A schedule, on parallel operating agreements, those sort of things can always be novated from the original applicant to successor and title. It takes a bit of time, as I said. There's a standard form novation agreement that NIE will sign up to, but again, being a sort of quasi public sector body, it takes a lot of time. At this stage, we're sort of at the point where we're ready to put our turbine up, bring our AD plant onto site. My colleague Conor Mulligan is going to run through, I suppose, the construction aspects of the project and what you need to have in place and what to look out for. If you want to go ahead, Conor.
Yep, thanks very much, Glenn. Hi folks, thanks for tuning in today. Just given the tight time frame that we're working under today, I'm going to keep today's focus on some useful contract information and some of the observations that we've seen in the market and our advice going forward. So Northern Ireland has seen a lot of success in bringing forward renewable energy projects and investment. Over the last 15 years, we've seen a lot of investment in and growth of renewable energy projects such as wind farms, anaerobic digestion plants and solar projects. And not only has NI become a market leader in this sector, but it's also shown real ambition to further progress. And on these projects, insofar as the legals are concerned, many of you will be aware of EPC contracts. They have traditionally been the most common form of contract used to undertake construction and engineering works by the private sector on large-scale, complex infrastructure projects across a variety of sectors, including power, water and waste. But that said, over the years, we've come across many projects in Northern Ireland where the contractual arrangements are a bit loose and informal, or Glenn said, had been winged. But while many EPC contracts are bespoke, some parties use standard form contracts as a starting point. And if the parties choose to use a standard form contract, it can be amended to address specific needs and project-specific issues. But I'd definitely be careful here when altering risk allocation, because that creates uncertainty as to parties' respective roles and responsibilities, and in turn can create its own problems. The International Federation of Consulting Engineers, or FIDIC, as it's more commonly abbreviated to, produces standard form contracts for civil engineering construction that are used throughout the world and are often referred to as the international standard form of contract for large energy projects. I'm sure many of you are aware of the commonly used FIDIC Yellow Book and Red Book. And well, I suppose our message about these published standard form contracts is that they're really good contracts. Definitely use them. And yes, you can tweak them as needed, but don't be reinventing the wheel when it comes to amendments. FIDIC states that their contracts allocate risk fairly to the party that's best able to bear and control that risk. But we all know that commercial drivers can often lead to contracts being amended to reflect parties' respective bargaining power. The more the risk taken by the contractor, the higher the cost paid by the employer. So just in relation to the FIDIC books, the Red Book is going to sit at the lower end of the risk spectrum for the contractor, which will reflect a lesser consideration. The Yellow is a bit more risky. And then finally, you have the Silver Book, which allocates the majority of the risk to the contractor, therefore requiring a higher consideration because price and cost will almost always be an inevitable issue. So Just to give an example, in terms of risk allocation under the red and yellow books, there's a number of key risks that the employer will retain, such as the risk of unforeseen physical conditions and some elements of cost risk for force majeure events. So force majeure is a bit of a legal term, which essentially it just means unforeseeable circumstances preventing you from fulfilling your contractual obligations. So, you know, like things like adverse weather or COVID. I thought I'd get through the webinar without dropping the C-bomb, but apologies, it was a good example. On the other hand, you've got the silver book, and under that book, the contractor will be responsible for all ground condition risk. So, you know, if nothing else, that's definitely an issue that needs discussed and agreed from the outset. And that's just one example of the differences in the FIDIC books, which hopefully gives an insight into the importance of selecting the right contract appropriate for your project, your resources, and your abilities. As we can see here on the diagram, a number of parties come into play on an energy project, both during the project, but also after it's completed. And that's why it's essential to document the link between the parties, their roles, and their responsibilities. And the best way of doing that is having a well-drafted and more importantly, understandable suite of contracts in place. The diagram here shows perfectly that there's a number of parties that you're linked to, you're involved with, and you're potentially liable to. And we can't stress more, and maybe it's a bit biased, but getting the lawyers involved from the get-go of an energy project is vital. Get your project contractual structure or matrix set up as early as possible, because, you know, too often we've seen projects go wrong due to really onerous and sometimes bordering legally unfair contract requirements. So getting the right legal advice prior to signing anything is paramount. You need to fully understand what it is you're involving yourself with and the implications or detriment you may encounter. And Mills Selig can help you get your energy projects right. To help clients, Mills Selig take a pragmatic approach by analysing contracts that can often prove unique to each project. The Northern Irish energy sector has been historically riddled with bespoke agreements rather than standard form contracts. And while there's nothing inherently wrong with bespoke contracts, I would note that bespoke agreements, you know, they're costly and they're time consuming to draft. And then any dispute arising out of that bespoke agreement is going to be costly and time consuming to resolve. So whilst the use of bespoke contracts can certainly work for clients, especially on large projects, it's inefficient for the market in general. When investors or purchasers consider energy sites in Northern Ireland, it's not appealing that every project's been done under a completely different bespoke contract, which can include really ambiguous and even unfair provisions. And as a general principle, unless there's good reason not to, we would encourage clients going forward to use a standard form published contract, albeit with a few amendments to create a bit more stability and consistency in the market, which will in turn result in projects being more attractive to investors. It seems that over the years, the energy sector in NI has been guilty of reinventing the wheel repeatedly by using bespoke suites of contracts. And in our experience, not all of those suite of contracts actually tie together properly to manage risk and project delivery. So two key contract provisions that I'd just like to touch upon today are delay damages and performance damages. Delay damages are usually a set amount of money that an employer will be entitled to deduct from the contractor for every week or day that a project runs late. So to delve more into the legals on this, and I promise I won't be too boring, under the common law, there was no requirement for the employer to prove that they actually suffered the loss provided for by the liquidated damages provision in their contract. And the employer would still be entitled to the amount of damages stipulated in their contract, even if their actual loss was lower. So that all sounds a bit too good to be true from an employer's perspective, but there was a catch. If the level of damages didn't represent a genuine pre-estimate of the employer's loss, then it was open to challenge by the contractor further down the line. So that common law principle was established, well over 100 years ago in a case called Dunlop and Matthew Tire Company and New Garage Motor Company. And basically, provided that the employer had made a genuine attempt to pre-estimate their loss, the court would be unlikely to regard a delay damage clause as a penalty. However, if the amount of liquidated damages bore absolutely no resemblance to the loss, or it was extravagant, or was intended to deter breach of contract, then the court would be more willing to construe it as unenforceable. The Supreme Court more recently presented a new test in the case of Cavendish Square Holdings and Tatal El Makdessi, requiring a consideration of the commercial justification for the liquidated damages clause at the time the contract was entered into. So it's clear now that there's going to be greater consideration required at the drafting stage of a contract in an energy project as to whether obligations are primary or secondary, and that's definitely going to provide fertile ground for dispute. So it's clear here that delay damages are critical on any energy project. And despite the case law on the issue being relatively complex, our advice is that parties must consider what a genuine pre-estimate of loss is if the work is going to be delayed. And you need to consider this before you include any sort of delay damage provision or amount in your contract. The parties, usually the employer, should be methodical and considered in calculating the amount to be included in a delay damages provision. The last thing parties want to do is end up in a legal dispute about whether delay damage figures are legally enforceable or not, because trust me, that's going to be an absolute mess. So when you're calculating an amount to be paid in the event of a breach, subcontractors and head contractors should consider the potential daily cost of employees and plant on site, and also daily business operation costs, as well as a few other project-specific risks. And while we appreciate that it's maybe a bit old-fashioned to talk about the notion of genuine pre-estimate of loss when it comes to delay damages, the case law definitely suggests that that's the correct approach. And whilst the court's not going to expect parties to be entirely accurate, there must be a genuine attempt at pre-estimating the loss in order for the court to hold your clause valid. And then performance damages, just briefly, mean liquidated damages resulting from the project's performance, which are required to be paid by the EPC contractor or any other material project party for or on account of any diminution to the performance of the project. So to put that simply, if your project includes that a turbine produces X amount of power, and then upon completion of the project, you run a few tests and the turbine's actually producing X amount below your intended power, then monetary deduction can be made and provision can be made within your energy contract for that amount. So I thought that was a good one to highlight today, because that's definitely going to require attention, from both an employer and a contractor perspective. And just to round off before I pass back to Glenn, if there's anything I'd like you to take away from today, it's to get the right legal advice before signing or entering an agreement, and where possible, use standard form contracts. The better the paper trail, the better it is for your business when it comes to investment. And definitely be careful with your delay and performance damages, because if it's argued that they're unenforceable, damages are at large, and that means that they could amount to more than the liquidated damages provided for in your contract. And as a final takeaway tip, if you're a contractor, I would ask for a cap on liability, because in the past, these were often rejected, and, but more recently, we're seeing more and more employers accept them, provided that your cap matches your insurance. So today we've only dealt with a few provisions from a construction aspect, and if there's a need for or a want for a full webinar on the role of construction contracts in energy projects, we'd be more than happy to look into providing that. Thanks very much, and I'll pass back to Glenn.
Thanks, Conor. So just moving on, I'm going to touch on sort of the corporate structure, back to my sort of days as a corporate lawyer. Maybe not going to be relevant to everybody, but just to point out that, look, if the intention is that you're going to put your project into a corporate vehicle, to do that at the very outset, to take the legal advice and the tax advice around that, and to ensure that you're not moving project rights or assets after value has been created in your project. You'll always need to ensure that where the company has been used, your contractor in the name of that company, your authorizations, your consents, your grid connections and everything are in the name of the company as well. It harps back to the first point that I raised about ensuring that you have everything lined up and accurate, because down the line it only ends up costing you. What we had seen a lot of, and they're still around, are joint ventures in particularly micro generation projects. Again, similar to the corporate structure, you know, if there's going to be a couple of shareholders, you'll need to get advice, be it the landlord having a stake, be it a funder having a stake, be it a generation unit provider having a stake, maintenance provider having a stake, to ensure that, you know, it's been accurately reflected and negotiated what everybody's rights are and how they get their value out of the project. Typically a joint venture agreement's going to cover how decisions are made, who has any vetoes or rights to decide things over other parties, that where other services to be provided. So you have the landlord, you have your maintenance company, you have somebody who's going to be carrying out construction works, that they're properly contracted in to what they need to do. How profits are extracted, usually if there's shareholder loans to cover the sort of setup costs, the outgoings, you'll have those extracted and repaid prior to dividends been taken out for tax purposes, and then just the ability of the exit. So who can buy another party out, who can force a sale of the vehicle. One slide just on funding, because we've been talking about that in and out quite a bit this morning. Most microgeneration projects, that there is going to end up being a financing at the start and a refinancing midway through the project. These processes always involve due diligence, from legal and from tax and usually accounting as well. So that's just important to make sure that project agreements, contracts and authorizations are robust and free from defects, as we've mentioned. The next point to discuss is power purchase agreements, which is a contract between the energy buyers and energy sellers in relation to a project. So typically micro generation, you're going to have the entity that owns the turbine selling power to what typically and historically would have been one of the utility companies in Northern Ireland, usually at a fixed price and at a much lower price than what they would be now. But what we're starting to see is a growth in what are corporate PPAs or direct PPAs, where the generating station owner sells the power directly to a business that's essentially getting a cut in its energy bills in return for taking all or certainly a majority of the power provided by the unit. Having your PPA lined up, having your sort of revenue generation side lined up is very important, obviously at the outset, to ensure that when the project starts to generate, that you have that sort of regular income stream that has been sort of hedged and that financially it makes sense for you. It gives financial certainty for utility companies and developers, removing a significant roadblock to financing and building the project. And they're also helping to be found deliver more renewable energy on the grid. Obviously, there's no longer any NIROCs available, depending what happens with the most sort of recent renewable energy policies and consultations that are ongoing at the minute, hopefully for a new energy policy more than strategy for Northern Ireland. A corporate PPA with a financially strong counterparty with a good covenant on the other side is an essential component for developing and achieving a bankable project. So whether you're entering into a PPA with a licensed electricity supplier, so one of the big sort of utility companies, or a short-term or more corporate style with an off-taker, the following headline terms will be within the agreement. So first of all, the most important point is a price or pricing mechanism. Will the price being paid be variable according to market rates? So obviously in the electricity market, if you're overnight rates, if your intraday rates, and obviously all subject to auction. So we have a number of pricing mechanisms that we put in our PPAs, just that are of a variable nature, and I don't expect to see too many fixed price or pure fixed price PPAs going forward, just with how the electricity market has been distorted so much in the last sort of probably 9 to 12 months. Pricing review mechanisms, like any of your contracts, it's have that ability if the costs are increasing or decreasing, if it's a variable rate, that there's some sort of way to review the price for either party. Are any of the sort of renewable certificates or additional benefits, the NIROCs, the REGOs, are they being bought or sold as well? Is it all of the power output? Is it a fixed number of units? Those are things that are going to have to be covered off in the PPA. With some purchase of power, you'll see guarantees of availability included, which obviously puts a bit of risk on the turbine owner, the generator. Again, term and an ability to extend that term will need to be reflected and considered by both parties. Termination rights, which we've touched before, similar to the lease. What happens if there is an event of default? If either party maybe wants to get out of the arrangement, in what circumstances can they do that? Force majeure is typically always included in a PPA too, just given the factors that can be outside of the reasonable control of the turbine owner, the digestion plant owner, the supplier generator, just to ensure that there is a bit of wriggle room and they get out of a bad deal in the event of unforeseen circumstances. Then the final section, just going to mention divestment and investment, which we've sort of touched on, whether or not you're going to attract some equity investment, some refinancing from banks. If you are a party that's looking to buy an already spinning turbine or producing station, it's important to make sure that all of these, particularly if there's NIROCs on the project, to make sure that everything's been done correctly and is robust, because we have seen a lot of instances where Ofgem are starting to do more regular audits to look into the NIROC process, basically because of how much money that's ended up costing the executive and the government, just to make sure there's no gaps in what's there, no inaccuracies, because they are trying to reduce rocks or suspend rocks, where that consent, that authorization's been sort of breached in any way. Again, if you're purchasing or you're selling, there's going to be warranties around what the project's been doing, how it was constructed, whether or not there are any issues. So those are all things to be aware of, I think, at the very start, if you're setting a project up, so that you're not met with any unexpected liabilities right down the line. Then just to finalize, we have just set out sort of 6 sort of key takeaways there, which have been sort of running theme throughout the webinar. Careful planning before committing funds and resources. Make sure you take advice at the earliest opportunity. Sounds like a sales pitch, but most likely going to save you some time and expense further on through the project. Ensure you've got your PPA, your revenue streams lined up and identified. map out what contracts and permissions that are needed, and ensure that all those contracts and everything is in place, is accurate and robust, and just sort of mention the construction elements too, to take advice that Conor sort of set out there. That sort of summarizes the webinar. That's us finished up. If anybody has any questions, as I said, if there's any particular property lease related queries, far away, and if I'm unable to provide responses, Anna Marie McAlinden, we'll have her email address on the next slide, hopefully. If not, contact me and I can pass it on. But look, we're here if anybody has any particular matters they want to discuss.
That's tremendous. Glenn, Conor, thank you both. I've learned something. I always do learn something when I listen to your webinars, but I'm really intrigued with the red, yellow, white books from FIDIC in terms of contractual risk. You know, that's helpful for those who are less initiated in the sector when they're approaching contracts, to have it color coded. We have a couple of questions, only a couple of questions. One of those, and you touched on it just there at the end, Glenn, in terms of the NIRO experience in Northern Ireland. We're aware that CEF and DFE are going to be doing a consultation later this year around renewable energy support, hoping that will emerge in 2023. Any learning points for that? And by the way, offline, we'll obviously be having a chat and feeding into our responses to that in due course. But without getting too political, is there anything that could be learned by the executive if they're going in that direction?
Yeah, look, and as David there sort of touched on, Mark, and you sort of alluded to, the executive primarily in this part of the world hasn't got it absolutely perfect with its incentives over the years, not just for renewables. I think the rocks are, you know, we've clients who have rock generating or rock attracting stations, and look, it's brilliant for those guys. It did do one thing, in that the amount of renewable energy that was created in Northern Ireland just, you know, went up exponentially. So, you know, it achieved that as a purpose, but I think we can all agree that it probably did that at a cost that was far more than it probably really needed to be. I think one of the biggest issues for me with it, you know, on us advising generators and I suppose some utility companies that acquire the power and acquire the, you know, the ROC certificates and everything too as part of that and trade them, is that it's not, you know, it doesn't quite correlate. You know, you have per unit of electricity, I think it's about 4 times better to have a single turbine for the ROC generation you're going to get than if you have, you know, multiple turbines or wind farms. That's why you're getting a lot of guys with vast numbers of turbines and they're sprouting them up all over the country. And I think also that why it went wrong at the time, who knows, but there was a lot of weight given to wind as opposed to the other technologies like the solar, and solar I think was stopped a bit earlier as well in terms of its ROCs. So you're starting to see a bit more solar now, I think, because the technology's got a bit cheaper. But I think industry advice, as David sort of touched on in terms of the consultation, industry advice needs to be taken. It needs to be taken from experts in electricity generation, experts in the renewables, from the construction companies, from even the guys that own and purchase the electricity, and probably not the lawyers, but we'll feed in if we're asked to.
Super. No, thanks for that. Listen, guys, that's been a tremendous run through. We're going to share the slides after the presentation as well. And as you say, you're more than happy to hear from anybody with any questions. So I'm just going to wrap up. Thank you again. Thank Mills Selig for your continual support. As I say, there's a number of other webinars coming up. They're all bookable on the CEF website. This has been recorded. Will be up on our YouTube channel as well, and we'll share that link after the event. So Glenn, Conor, thank you both very much on behalf of the members and everybody logged in. Thank everybody for taking the time today, and I hope you all got some value out of it. Thanks very much.
Thanks, Mark.
Thank you.